DD client rights during discharge, transfer, and termination. Hi, I'm Noah Seidel from the Office of Developmental Disability Ombuds. This video is about your rights during discharge, transfer, and termination of residential services. In other words, what to do when your residential provider tells you that you have to leave or they will no longer serve you. DD clients that receive certified community residential services, such as supported living, state-operated living alternatives, and group training homes, have the right to remain with the provider. Your services must not be terminated unless the provider determines and documents that they cannot meet your needs, or your safety or the safety of other individuals where you live is endangered, or your health or the health of other individuals where you live would otherwise be endangered, or the provider ceases to operate, which means the provider closes its programs. Now, Tim McHugh will tell you about how you receive this written notification.
Hi, I'm Tim McHugh from the Office of Developmental Disabilities Ombuds. You should receive written notice from the provider at least 30 days before your services are terminated or potentially terminated. Your notice must be provided to you and your legal representative or necessary supplemental accommodation representative. The notice must include the reason for termination of services and the effective date of termination of services. You and your legal representative or necessary supplemental accommodation representative should receive a transition plan at least 2 days before your services end. The transition plan must include the location where you will be transferred, how you will get to the new location, and the name, address, and telephone number of the Developmental Disabilities Ombuds. If you live in a long-term care facility or an adult family home, you also have rights in the long-term care residence rights.
Hello. My name is Sean Latham from Allies in Advocacy. We believe people with intellectual and developmental disabilities deserve to have their rights respected in where they live and what services they receive at their residential setting. You have the right to be notified if your residential provider wants to discharge you from their services. The reason has to be based on a legal reason and not just a reason about personality differences or challenges.
I'm John Lemus of the Lilac City People First Chapter. If you are a client of DDA and receive services from a certified residential provider, your provider can't just kick you out for no reason or without proper notice. This is the law. If you have trouble understanding your rights, please talk to the Office of Developmental Disability Ombuds or to someone you trust.
If you have concerns that your rights are being violated or would like to learn more about your rights, you can contact the DD Ombuds at 833-727-8900, at info@ddombuds.org, or at www.ddombuds.org. This is a production of People First of Washington State, with special thanks to the Office of Developmental Disabilities Ombuds.